Welcome back to the Constitutional Clarion. Following on from my last video, which dealt with the disqualification, expulsion and suspension of members of Parliament for criminal acts and other forms of serious misbehaviour, this video will discuss the current proposal to discipline members of Parliament for inappropriate workplace behaviour such as bullying and sexual harassment. It stems from an inquiry conducted by the Sex Discrimination Commissioner, Jenkins, which resulted in the Set the Standard report, which was tabled in both Houses of Parliament on the 30th of November 2021. It proposed the establishment of an independent Parliamentary Standards Commission. It recommended a new system under which the Commission would receive allegations of misconduct and provide support to those making them. The Houses would delegate their powers to the Commission. This would include power to enforce codes of conduct by investigating complaints of misconduct and making findings of misconduct. The Commission would have the power to impose low-level sanctions, such as requiring an apology or that the member undertake training. It could even order the withdrawal of services and facilities if they do not affect the core functions of a parliamentarian. For more serious sanctions, the Commission would recommend that the House impose them. These could include withdrawing services and facilities and other personal restrictions that do affect the core functions of a parliamentarian, dismissing the member from a select committee, withholding their salary and allowances, withholding their budget for staff positions or communications, or suspension of the member. The House would then vote upon the application of the sanction. The complaint and investigation process would be confidential. There would also be an appeal process from the Commission's findings of misconduct to a differently constituted panel of commissioners. Now, those were the recommendations of the report, but some of them were constitutionally problematic. First, there was the problem of the Commission having the potentially conflicting roles of providing advice and support to victims, investigating complaints, determining misconduct, setting the penalty, and either directly imposing it or recommending its imposition. Combining such roles in the former Human Rights and Equal Opportunity Commission, particularly where enforcement was involved, was found to be unconstitutional in the Brandy case back in 1995 and is generally not a good idea. There was also a potential separation of powers problem that would arise from imposing a punishment, such as a fine. While the Houses of the Commonwealth Parliament, unlike the New South Wales Parliament, do have anomalous, historically based powers to punish, the power to find that a person has committed an offence and to punish them is otherwise exclusively held by the courts. While the Jenkins report sought to get around that problem by having the Houses delegate their powers to the Commission, it seems doubtful that the courts would accept the constitutionality of that extension of these powers to a Commission which is not even comprised of any members of Parliament. It's understandable, therefore, that the government's response to the report, as set out in the Parliamentary Workplace Support Service Amendment, Independent Parliamentary Standards Commission, Bill, which I'm just going to call a bill for obvious reasons, is slightly different from what the Jenkins report proposed. So in this video, I'm going to go through the bill and how it would work so you can understand the issues. First, under the government scheme, the roles are separated out so that support for complainants rests with the separate Parliamentary Workplace Support Service, which can also undertake cooperative complaint resolution. The role of investigating and making findings of fact is given to the Independent Parliamentary Standards Commission. For the most part, sanctions are only imposed by the House, but I'll come back to that. If the bill is passed, it will establish an Independent Parliamentary Standards Commission comprised of a chair and between 6 and 8 other commissioners. Unusually, it stipulates in proposed section 36(b) that at least 4 commissioners must be women. The commissioners are to be appointed by the Governor-General on the advice of the relevant minister. Before that happens, however, they must go through a selection process that the minister is satisfied was a merit-based process, and they must be approved by the Parliamentary Joint Committee on Parliamentary Standards. To be qualified, a commissioner must be a legal practitioner of at least 5 years standing, or a former judge, or a person who has skills, knowledge, or experience in investigating workplace misconduct. Now, if you're wondering whether there is so much misbehaviour in Parliament House as to warrant the employment of 7 to 9 commissioners, you'll be relieved to know, as was I, that the appointments are actually part-time. The role of commissioners is to investigate and make findings about whether conduct by members of Parliament or staffers breach a code of conduct. There will be separate codes of conduct approved by resolution of each House of Parliament, and also a code of conduct applicable to people employed under the Members of Parliament Staff Act 1984. In this video, I'm just going to concentrate on the application of this bill to misbehaviour by Members of Parliament rather than staff. The Act applies to conduct that breaches a code. These codes were developed by the Joint Select Committee on Parliamentary Standards and given preliminary endorsement by the Houses of Parliament in February 2023, pending the passage of this particular bill. The Code for Parliamentarians lists prohibited behaviours as bullying and harassment, sexual harassment and assault, and discrimination in all its forms, including on grounds of race, age, sex, sexuality, gender identity, disability or religion. In addition, it requires parliamentarians to comply with all laws. They must also treat people with dignity, courtesy, fairness and respect, which I suspect might be a challenge for some of them. The Commission can also address pre-code conduct, which it lists as sexual assault, sexual harassment, bullying and unreasonable behaviour towards another that creates a risk to work health or safety. If there is a complaint or a referral made to the Commission about pre-code conduct or a breach of a parliamentary code of conduct, there are significant hurdles in the way of getting it investigated or any sanctions imposed. First, proposed section 24CH says that the Commissioner may decide to investigate only if the Commissioner is satisfied on reasonable grounds that there is sufficient evidence or information to justify doing so. The problem with such a test, of course, is that it puts the horse before the cart. Often there will not be sufficient evidence until it's gathered as part of the investigation process. It appears from the explanatory memorandum, however, that a Commissioner is able to resolve that problem by making preliminary inquiries, including exercising information gathering powers and issuing confidentiality notices for the purpose of deciding whether or not to investigate, which on its face seems to be quite bonkers, because surely then they actually are investigating. There's also a separate discretion to decide not to investigate a complaint or a referral if the Commissioner is satisfied that it's frivolous, vexatious, misconceived or lacking in substance, or was not made in good faith. And you can understand how important that might be in a politically partisan place like Parliament. Second, if the conduct involved may constitute a serious offence against a person, such as a sexual assault, and that person does not consent to the investigation, then the Commission is also prohibited from investigating. This is apparently to ensure the agency of complainants in such matters. The explanatory memorandum also notes that serious offences should be investigated by the police rather than the Commission. Third, in most cases, the consent of the complainant will be required before the Commission can investigate, unless the Commissioner is satisfied that a serious risk to work, health or safety arises or could arise from the conduct concerned. Fourth, Commissioners are also prohibited from investigating if the conduct forms part of parliamentary proceedings for the purposes of Section 16 of the Parliamentary Privileges Act 1987. There's good legal reason for doing this, but the consequence is that the legislation will not address a lot of the matters that people have complained about when seeking this reform. For example, conduct in the chamber, such as bullying and abuse, sexist comments, drowning people out, and that quite insidious, quiet but persistent sledging which occurs in a way that can't be picked up by Hansard. All of this would be excluded. These matters would remain the preserve of the House and its presiding officer to deal with. Some of the most brutal bullying in Parliament happens in political party contexts, either in party room meetings where threats to pre-selection are sometimes made, or in the context of leadership challenges. You might remember the challenge by Peter Dutton to Malcolm Turnbull's leadership in 2018, and that it was marked by a number of claims by female MPs in particular of bullying and intimidation. But no one was actually prepared to name the alleged bullies or detail their actions. As a general principle, parliamentary privilege does not extend to protect political party meetings, including, presumably, leadership challenges. It might be otherwise, however, if the matter was closely tied to a vote in the House, such as a vote of no confidence. Even though there are provisions in the bill to protect those making disclosures from being subject to detriment, it's likely that fear will still constrain people from making complaints against MPs who are regarded as powerful within a political party. On the other side of the equation, proposed Section 24CP says that if the respondent to a complaint, that's the person who's complained against, is a member or senator, he or she must cooperate with the investigation. But there seems to be no penalty for failing to do so, although it would amount to a breach of the Code of Conduct, which requires cooperation. Commissioners are, however, given the power to require a person to produce documents, give information, and attend private interviews to answer questions, and it's an offence to fail to comply. But again, this cannot be done in a way that interferes with parliamentary privilege. There's also an exemption for journalist sources, and both legal professional privilege and the privilege against self-incrimination apply. Once an investigation is complete, if the respondent is a current or former parliamentarian, then a panel of commissioners is established comprising the investigating commissioner and two others. It considers the evidence and the material that was gathered in the investigation and prepares a draft report setting out findings of fact, a summary of the evidence, and any proposed recommendations or sanctions. A copy is given to anyone who is criticised in the report or the subject of proposed recommendations or sanctions, who can then comment on it as a matter of procedural fairness. After considering any responses, a final report is produced. It sets out whether the panel is satisfied on the balance of probabilities, which is the civil, not the criminal standard, that the respondent engaged in conduct that breached the code. This does not amount to a finding of guilt in relation to a criminal offence, as only a court could make such a finding. The panel may also impose sanctions, including a written reprimand, a requirement that the respondent undertake training, or that the respondent enter into an agreement about future behaviour. There does not appear to be any power to enforce those sanctions, however, presumably, again, for separation of powers reasons. However, there is a quite cunning political punishment allowed. If a parliamentarian fails to comply with a sanction imposed by the panel, the Commission may sweep aside the veil of secrecy that covers all these proceedings and publish a statement about the matter which must include the identity of the parliamentarian. So, if you don't comply, you get outed. More serious sanctions can only be imposed by the relevant House of Parliament. If the Commission panel finds that there has been a serious breach of the Code, then it can refer the matter to the Privileges Committee of the relevant House. However, the panel may only do so if satisfied that this is, quote, necessary to promote appropriate conduct in Commonwealth parliamentary workplaces, unquote. That's a rather odd and high standard, necessity, to apply before dealing with a serious breach of a code of conduct. The explanatory memorandum says that this is to show that the measures are intended to protect the parliamentary workplace and the functioning of Parliament. It is probably, therefore, an attempt to shore up a head of legislative power to support this legislation, which would include both Section 49 of the Constitution in relation to the powers and privileges of Parliament and the legislative power in Section 5139 of the Constitution to make laws that are incidental to the exercise of any power vested by the Constitution in either House of Parliament or the government, such as a power to administer the public service. Before any reference to the Privileges Committee occurs, both the respondent and the complainant can seek a review of the panel's report by a differently constituted panel. If, after any review has been completed, there remains a finding of a serious breach, the panel may refer it to the Privileges Committee of the relevant House. The Privileges Committee must consider the matter on a confidential basis and then decide whether to recommend to the House that it impose a parliamentary sanction on the respondent. Now, this type of sanction could include suspension for a period permitted by the standing orders, which is up to 7 sitting days in the House of Representatives and up to 14 sitting days for the Senate. It could also include removal from a parliamentary committee or the deduction from a member or senator's annual base salary of a fine of an amount between 2% and 5%. Now that's around $4,700 at the lowest level and $11,600 at the highest level. The committee may also recommend any other sanctions that it considers, quote, necessary to promote appropriate conduct in Commonwealth parliamentary workplaces, unquote. Once the committee's report is tabled in Parliament, then, and only then, the matter becomes public. It's interesting that the bill does not refer to all the other sanctions proposed in the Jenkins report, such as withdrawal of services and facilities from the parliamentarian and withholding a parliamentarian's budget for staff positions or communications. I'm guessing that this is because it would impact upon the ability of a parliamentarian to fulfil his or her duties and therefore raises privilege problems. After the House has considered the report and the recommendations of the Privileges Committee, it can pass a resolution to impose the recommended sanction or any other sanction that the House considers necessary to promote appropriate conduct in Commonwealth parliamentary workplaces. If it decides to impose a fine, then the Secretary of the relevant parliamentary department is authorised to deduct the amount from the respondent's pay. From a constitutional point of view, it's the fine that's the trickiest part, because it's clearly a punishment that ordinarily only a court could impose. The Houses of Parliament, however, were granted by Section 49 of the Commonwealth Constitution the same powers that the House of Commons had at the time of Federation. This certainly covered suspension and expulsion, as mentioned in the previous video, but there were doubts about whether it also included the ability to impose a fine. Section 49 also allows the Commonwealth Parliament to legislate about the powers of the Houses, and it has. Section 7, subsection 5 of the Parliamentary Privileges Act 1987 of the Commonwealth says that a House may impose a fine on a person that does not exceed $5,000 for an offence against the House if the House determines the person has committed the offence. Section 4 of that Act also says that conduct, including speech, does not constitute an offence against a House unless it amounts to an improper interference with the free exercise by a House or a committee of its authority or functions, or interferes with the free performance of a member's duties as a member. But the fines under this new bill are not for offences against the House, as that would fall within the field of privilege, and the bill specifically excludes conduct that forms part of parliamentary proceedings. This leaves open an interesting question of whether Parliament can legislate to confer power on the Houses to fine members as a punishment for matters that extend beyond matters within parliamentary privilege, without breaching the separation of powers by exercising an exclusive judicial power of punishment. I guess we will only find out if someone challenges it. Now, those of you who are up to date with such things will wonder why on earth I have been referring to a bill when it has already been passed by Parliament. Well, I filmed the earlier part of this video a little while ago, and it has since been overtaken by the speedy passage of the bill in Parliament. So I'm making this extra little coda to attach to the end of the video. While some amendments were made to the bill concerning the makeup of the Supervising Parliamentary Committee, they were government amendments. Other proposals to reform the bill were defeated. For example, the member for North Sydney raised a concern that there were no guarantees that the findings of misconduct by parliamentarians would be made public. She was also disturbed that the imposition of serious sanctions was left to the discretion of the Privileges Committee rather than the Independent Parliamentary Standards Commission. I agree that there are real issues around the confidentiality aspects of this process, but the reason for leaving sanctions such as suspension and fines to the Privileges Committee and ultimately to the House is a constitutional one, because the House has the power to punish members. If a commission tried to do that, it would be vulnerable to having its powers struck down as a breach of the constitutional separation of powers. The member for Wentworth raised concerns that the Commission's remit does not extend to conduct in the chamber. She said that there is no other workplace environment where shouting, mocking, and hurling insults is not only tolerated, but celebrated. She noted that it sets a terrible example and does nothing to support constructive discussion and social cohesion. True. But unless one dismantled centuries-old rules concerning parliamentary privilege, such internal matters really are a matter for the Houses themselves and cannot be controlled by an outside commission. But the member for Wentworth also argued that the Code of Conduct should be embedded in the House's standing orders and that real steps should be made to improve behaviour in the House. Quite so. The member for Clark moved a motion that the Commission make recommendations to the Privileges Committee about specific sanctions and that the Privileges Committee then be obliged to report reasons for not following those recommendations. That seemed quite reasonable to me, but it was also rejected. Other amendments raising similar issues were also raised and rejected in the Senate. So the Act is now passed, and it will be interesting to see how effective it is, or whether we can even make an assessment about its effectiveness given the secrecy surrounding it. Like the National Anti-Corruption Commission, it may well be that the public just can't see what it's doing because its investigations are done in secret, and that can lead to distrust and a lack of confidence in the system. The courts do have this principle of open justice for a reason. People need to see justice being done in order to have confidence in it. It seems that politicians are not so keen on principles like open justice and transparency and accountability when it comes to investigations into themselves. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.